Welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading.
Today, we are going to discuss the New Delhi edition of the Hindu newspaper dated 28 September 2018. The news to be discussed has been presented on the screen before you. Time stamping for the same has been provided in the description box below. Let's start our today's discussion. So, in this particular news, the Supreme Court of India has struck off the concept of adultery from our legal books. This news appears on page number 1 as an editorial on page number 8 and also appears throughout the newspaper on page number 11. On page number 1, the news reads, Adultery is not a crime, rules Supreme Court, strikes it off IPC, where the Chief Justice of India says how couples deal with the case of adultery is a private matter. It further said that Section 497 of the Indian Penal Code treated a woman as the husband's commodity. The editorial mentions that by decriminalizing adultery, the Supreme Court strikes a blow for individual rights. Here on page number 11, the Chief Justice of India has said in the judgment that don't bring adultery back as a crime to the Parliament. Justice Nariman has mentioned that Section 497 was archaic, and Justice Chandrachud has mentioned that man is not owner of wife's sexuality and she can make her own sexual choices. So let's understand this particular Constitution Bench judgment by understanding what actually adultery provided for in Section 497 of Indian Penal Code. Now this particular judgment forms a part of GS Paper 2 under Constitution and Governance. Now Section 497 of Indian Penal Code provided imprisonment for the case of adultery, and the imprisonment could have been for a term which may extend to 5 years or with fine or with both. And in such a case, the wife shall not be punishable as an abettor. So let's understand what this concept of adultery actually was as per Section 497. So here you can see, when a man, both married or unmarried, has sexual intercourse with wife of another person and without the husband's consent, then such sexual intercourse, if not amounting to rape, amounts to the offense of adultery. So this is what exactly the case of adultery was. That if a person has sexual intercourse with wife of another person without the husband's consent, and if such an act did not amount to rape, then that act could have been considered the offense of adultery. Now this is another important section mentioned here, Section 198 Clause 2 of Code of Criminal Procedure. It says that only the aggrieved husband can file the case of adultery against another man who had sexual intercourse with his wife without his consent. So as per Section 198 Clause 2 of CRPC, it said that only the aggrieved husband can file the case of adultery against another man. So both Section 497 of IPC as well as Section 198 Clause 2 of CRPC, that is Criminal Procedure Code, were challenged in the Supreme Court as it violated Article 14 of the Indian Constitution, that is right to equality. So in this case, a 5-judge Constitution bench has held that adultery is not a crime and has struck it off from the Indian Penal Code. The court has also struck down Section 198 Clause 2 of CRPC, which allowed only the aggrieved husband to file a case against another person of adultery. The court has further held that adultery can now be considered as a ground for divorce. The court said that Section 497 of IPC perpetuates subordinate status of women, denies dignity to women, as well as denies sexual autonomy, and is based on certain gender stereotypes. So these were the reasons why the court struck off Section 497 of Indian Penal Code from the law books. The court in this aspect held that how couples deal with the case of adultery is absolutely a matter of privacy at its pinnacle and is left with the two adult people to deal with the problem. The court used a strong word and said that Section 497 of the Indian Penal Code treated a married woman as a commodity or the chattel of the husband. The court also said that Section 497 is a reflection of social dominance of men prevalent since the last 150 years. The judgment, by getting rid of Victorian era morality, has helped the cause of individual rights to flourish without any discrimination. With decriminalization of adultery, India has taken steps towards right-based social order instead of a state-imposed moral order. Another important aspect mentioned by the judgment is that autonomy in matters of sexuality is intrinsic to a dignified human existence. Thus, The judgment struck down adultery as it subjugated a married woman entirely to the will of her spouse. And this impacted the concept of equality in an equal relationship between the husband and the wife. Thus, this news on Supreme Court striking down adultery becomes extremely important from our exam perspective. With this, let's move on to the next news. This news appears on page number 8 in the lead article section. It says, finding an equilibrium. The Supreme Court's verdict in the Aadhaar case is the best read in light of dissenting opinion. In this aspect, the dissenting opinion in the 5-judge constitution bench was given by Justice Chandrachud in the case of Aadhaar. This particular topic forms a part of GS paper 2 under Constitution and Governance and also a part of Ethics, Integrity and Aptitude, as associated issues mentioned in the article have been asked in the ethics paper of GS4. Some of the questions asked in GS4 were, some people feel that values keep changing with time and situation, while others strongly believe that there are certain universal and eternal human values. Give your perception in this regard with due justification. Now, this is a very general opinion, and questions like this can always be asked with respect to changing times. As we have already seen in the last few years that Supreme Court has given various judgment with respect to our changing times, either be it case of Aadhaar, either be it case of right to privacy, which is now declared as a part of fundamental right, or even the case of adultery. So we see even the Supreme Court with changing times is seeing the constitution and interpreting the constitution in a very different way as compared to before. In this aspect, this particular question was asked in the year 2016. It said, analyze John Rawls' concept of social justice in the Indian context. Now, this concept of social justice becomes extremely important from this point of view because the majority decision, while declaring the constitutional validity of Aadhaar, based their decision on the concept of social welfare as against individual privacy. We'll see all these things in detail. So these questions which have been asked previously tells us a way that what are the things that may become important and can be asked in future examinations. So in this aspect, since John Rawls was asked, hence other theories with respect to either social justice or in general justice becomes extremely important from us from our UPSC point of view. Now from GS paper 2, two questions were asked in the year 2017 itself. One of them was to critically examine a particular Supreme Court judgment, and this question was based on National Judicial Appointment Commission. So we see that even questions based on critically examining a particular judgment has been asked by UPSC. So in this aspect, it actually becomes very important to understand the dissenting opinion of Justice Chandrachud, as in what he had to say on the entire issue of Aadhaar, particularly with respect to Aadhaar being declared as a money bill. Another question with respect to right to privacy was also asked. It says, examine the scope of fundamental rights in the light of latest judgment of the Supreme Court on right to privacy. So we see basically that UPSC has of late now trying to ask current questions based on social issues which actually impact our day-to-day life. And if there are certain constitutional judgments on the same, then it becomes very important for us to understand. I hope from yesterday's DNS covered by Basava sir, you must have understood the intricacy of the judgment. So in this analysis, let us understand what the author tries to highlight with respect to the dissenting opinion. First of all, let us understand some of the important highlights of the article as mentioned. It mentions about right to privacy vis-a-vis Aadhaar's constitutional validity. Secondly, whether issue of surveillance and social welfare provide constitutional grounds for reasonable restrictions on ground of privacy. So we understand that even right to privacy as declared by the 9-judge constitution bench is subject to certain restrictions. Then this article highlights about the finality of Lok Sabha Speaker's decision on what amounts to a money bill, as the Aadhaar bill as a money bill was declared to be constitutionally valid. Now this article mentions about a particular statement from the judgment of Sajjan Singh versus State of Rajasthan, where it says, can the constitution become a plaything of the majority? Now this statement becomes extremely important because this particular line paved way for further enactment of the very famous basic structure of the Indian Constitution, which was decided in the case of Kesavananda Bharati versus State of Kerala. Further, this article highlights about two tests. One is the ultimate test and the second is the proportionality test. And finally, the author also highlights about a theory of Roscoe Pound on balancing of interest in the society. So first of all, let us start with the restriction based on right to privacy as decided in the Puttaswamy judgment. It says limitations on right to privacy, where it has been mentioned where the judgment said that right to privacy is not an absolute right like any other fundamental right. And it says that any law which encroaches upon the privacy will have to withstand the touchstone of permissible restrictions on fundamental rights. So if Aadhaar was to be held constitutionally valid, then it must have withstand the touchstone of permissible restrictions. So it says that in this context of Article 21, an invasion of privacy must be justified on the basis of a law, in this case the Aadhaar law, which stipulates a procedure which is fair, just and reasonable. So this particular act must be fair, just and reasonable, and also for a specific purpose. This further says that an invasion of life or personal liberty, as mentioned in Article 21, must meet the threefold requirement of, first of all, legality, that the law concerned must be legally valid, which postulates the existence of a law, need defined in terms of legitimate aim of the state. And third, proportionality. As mentioned above, this article also highlights about the proportionality test. It says a proportionality which ensures a rational nexus between the objects and means adopted to achieve them. So the Aadhaar Act must have been legal, it must have justified a particular need in the society, and must have passed this test of proportionality. So in this aspect, let us understand the majority decision specifically on money bill as well as the dissenting opinion of Justice Chandrachud, as these aspects becomes critically important for us to write our answers. Now, on decision of the speaker, Justice Bhushan on the majority judgment said that the decision of the speaker is not immune from judicial review. But still, the justice took the view that speaker's decision in declaring Aadhaar as a money bill did not violate any constitutional provision, and hence this cannot be called for an interference in the proceeding. It means that the Aadhaar bill passed as a money bill was constitutionally valid. However, there was a dissenting note as mentioned by Justice Chandrachud, who fully disagreed and held the Aadhaar law as invalid and also as a fraud on the constitution. He says that it is a colorable exercise of constitutional power. He further says that the purpose of a law cannot be to shield an excess of power. So here he is talking about notion of absolute power and also a notion of excess of power, where it says that the purpose cannot be to shield an excess of power from being questioned before the court. Further, Justice Chandrachud said, can there be a case in which no judicial review is required with respect to any constitutional decision taken by any person holding a constitutional office or a constitutional chair, where he mentions about the ultimate test in this regard. So he says effectively that only in such cases judicial review can be disallowed where a particular decision of the government is to achieve a constitutional purpose. And in this aspect, Justice Chandrachud also highlighted that interpretation of the constitution in modern and present times must subserve the need to liberate it from colonial detritus. It simply means that in present circumstances, the interpretation of the constitution should meet present requirements. So saying all these aspects, Honorable Justice Chandrachud holds that decision to give Aadhaar bill the status of money bill violates the principle of bicameralism. And according to Justice Chandrachud, this principle of bicameralism has also been declared as a part of basic structure. Now this again becomes very significant aspect as mentioned by Justice Chandrachud. And further, Justice Chandrachud also said that it was also a part of federalism, which again is a basic structure. And according to him, such basic structure of the constitution cannot be trampled with. In this, he highlights the fact that institutions are important to democracy and devaluing them can cause peril to democratic structures. Now, this particular statement becomes extremely important as directly a question can be framed on this particular statement and you can be asked to critically examine this particular statement or also give your opinion on this statement So we see that some of the statements given by these justices which pertains to democracy and rule of law becomes equally important for us to understand. So whatever dissenting opinions we just mentioned becomes important for us not only to understand why Justice Chandrachud said certain things but also to assess what is the impact of the things said by him. The article also highlights about a proportionality test where it talks about balancing of interest. And it is here where theories of Roscoe Pound becomes very important. So here on the issue of balancing of interest, the majority decision relied more in the favor of social justice as compared to individual notions of privacy. Remember this concept of social justice? A question in the year 2016 was asked in your GS paper 4, that is ethics, that analyzed John Rawls' concept of social justice in Indian context. So we see that understanding this proportionality test becomes extremely significant from us from our UPSC point of view. Now here interesting fact is that the majority felt that some loss of privacy is constitutionally permissible to achieve public good for the marginalized sections of the society. Now we have already discussed that on limitations of right to privacy, a law can be framed if it meets the threefold requirements of legality, need as well as proportionality. So it is here where this concept of proportionality test becomes important. And it says here the collective right to privacy for greater good was considered more sacrosanct, which could have override individual right. So here we see a case of collective rights versus individual rights, where collective rights were considered more sacrosanct or more purposeful. Now, Roscoe Pound developed the theory of law as an ad hoc balancing of interest, where a law is made considering sacrificing certain aspects and supporting other aspects for the time being. So, in the case of Aadhaar, it has sacrificed the notion of individual right to privacy for certain greater good which can be achieved for certain marginalized section of the society. So after understanding this proportionality test and also the theory given by Roscoe Pound, let us also go through some of the important facts as mentioned by John Rawls. It says that Rawls' theory of justice revolves around the adaptation of two fundamental principles of justice, which in turn guarantee a just and morally acceptable society. Where it says that the first principle guarantees right of each person to have most extensive basic liberty compatible with liberty of others. So here also we see the case of individual liberty incompatibility with liberty of others. The second principle states that social and economic positions are to be for everyone's advantage and open to all. So it also talks about social and economic positions of people in the society. Rawls says that conception of justice is an inherent nature of our social as well as practical life. He further states that we cannot imagine of a well-ordered society whose core concept is not justice, as justice binds all men and institutions of society. So effectively, John Rawls attempts to solve the problem of society or social structure through redistributive justice, where it says the social institutions are very important in the sense that they take the responsibility of distributing the fundamental rights and duties efficiently. So here we see that Rawls' theory is based on the concept of redistributive justice among all and in an equal manner. Thus, this particular article by a legal luminary highlights some of the most important aspects not only with respect to law and justice but also with respect to society in general. So, this particular article becomes extremely important. As we have seen, questions have been asked either directly or indirectly, either on a judgment or on based on certain theories of social justice. Hence, this article becomes very important. With this, let's move on to the next news. The next news appears on page number 8 in the article section. It says, Idlib, the final frontier. The Putin-Erdogan deal may have postponed a battle, but the war is far from over. Now, in this particular article, let us find out where this place Idlib is, as such questions have been asked previously by UPSC, and this topic forms a part of world geography. So let us see some of the questions asked previously by UPSC in the prelims examination. Now recently in the year 2018, this particular question was asked. Consider the following pairs. Aleppo, Syria, Kirkuk, Yemen, Mosul, Palestine, and Mazar-e-Sharif, Afghanistan. Now you can see in the map where are these towns actually located. So starting with Aleppo, we see Aleppo is located in Syria. So the first option is correct. Second, Kirkuk. Kirkuk is also located in Iraq, but the option given here is Yemen. So this option was incorrect. Second is Mosul. We see that Mosul is located in Iraq. So again this statement is incorrect, as it says Mosul is located in Palestine. And the next is talks about Mazar-e-Sharif in Afghanistan. So we can see Mazar-e-Sharif located in Afghanistan. So by looking at the map, we can easily identify where these places have been situated. So here the correct answer was 1 and 4, that is B. Now this particular question was asked in the year 2017. Let's look at the map first of all. As per the map, this is the Mediterranean Sea. So the question asked was, Mediterranean Sea is a border of which of the following countries? So the options given were Jordan. We see that Jordan is not on the border of Mediterranean Sea. So here first option becomes incorrect. Second option says Iraq. So in the picture we see that Mediterranean Sea does not share its bank with Iraq. So again Iraq becomes incorrect. Next is Lebanon. Now this is Lebanon and it shared its banks with Mediterranean. So this is a correct option. And also Syria, as you can see in this particular map. So in this question, C was the correct answer, that is 3 and 4 only. So we understand that with the help of a map, it becomes very easy to identify important places which have been in news. So in this respect, even going through the World Atlas becomes extremely important to identify important cities which are in news. Now the question asked in the year 2016 was, consider the following pairs, communities sometimes mentioned in the news. The pairs given are Kurds, mentioned in Bangladesh. No, Kurds are not found in Bangladesh. They are found along the borders of Turkey and Iraq. Next, Madheshi, Nepal. Yes, this is correct. Rohingya, Myanmar. This is also correct. So we see 2 and 3 becomes the correct answer. That is, C is our correct answer in this particular question. Now the question asked in the year 2015 was, the area known as Golan Heights sometimes appears in the news in the context events related to. Here the correct answer is B. So we see map based questions have been asked by UPSC. Hence in this aspect it becomes important to know about Idlib. Idlib is located in Syria. So this article talks about an agreement between Russian President Vladimir Putin and Turkish President Recep Tayyip Erdogan to prevent an all-out attack on Idlib, which is in Syria, as Idlib is considered to be the last major enclave held by anti-government militants in Syria. So in this aspect it becomes important to know where the place Idlib is. With this, let's move on to the next news. The next news appears on page number 9 in the conceptual section. It talks about Brownian motion. Now this particular topic forms a part of general science under your prelims examination. Brownian motion refers to the erratic movement of microscopic particles as a result of continuous bombardment from molecules surrounding the medium, which you can see in this particular picture. These fluids can be either water or even oil. Now Brownian motion is also known as pedesis, and the word pedesis comes from a Greek word known as leaping. Brownian motion takes its name from the Scottish botanist Robert Brown, who observed pollen grains moving rapidly in water. So in this aspect, some of the examples of Brownian motion can be, it says that most examples of Brownian motion are transport processes that are also affected by larger currents and also exhibit pedesis. Now examples include motion of pollen grains on still water, movement of dust motes in a room, diffusion of pollutants in air, diffusion of calcium through bones, and movement of holes of electrical charge in semiconductors. It says that the initial importance of this Brownian motion was that it supported the modern atomic theory, and today the mathematical models that describe Brownian motion are used in maths, economics, engineering, physics, biology, chemistry, and a host of other disciplines. So we see there are lots of industrial application with respect to this Brownian motion. Hence, in this aspect, it becomes important to understand the basic principles about Brownian motion. That it is the study of erratic movement of microscopic particles in a fluid which is as a result of continuous bombardment from molecules surrounding the medium. Hence, this concept of Brownian motion becomes extremely important. With this, let's move on to the next news. The next news appears on page number 13. The news reads MDR reimbursement pending from banks. It talks about MDR, that is merchant discount rate, reimbursement pending from banks, fears over banks retaining a bulk, the Payment Corporation of India. Now, this particular topic forms a part of Indian economy under your prelim section. And this topic of MDR, that is merchant discount rate, becomes very important as question was asked in the prelims of 2018. First of all, let's go through the question asked in the year 2018. It said, which one of the following best describes the term merchant discount rate sometimes seen in the news? So we understand that UPSC is trying to ask most relevant questions which are appearing day to day in our daily news. So merchant discount rate is a charge to a merchant by a bank for accepting payments from their customers either in credit card or in debit card. It says that a merchant discount rate is expressed in the percentage of transaction amount. Now, in this aspect, the Reserve Bank of India has reduced the merchant discount rate for debit card transactions and prescribed separate cap for small and large merchants based on their annual turnover. So, the RBI first of all reduced this MDR for debit card transactions and provided a separate cap for small and large merchants. The move is aimed to encourage merchants to accept online mode of payments. So further in this particular news, the Ministry of Electronics and Information Technology, in a bid to encourage digital payments in India, had issued a notification in December 2017 stating that the government will reimburse the MDRs on transaction below 2000 rupees if those transactions were made by either debit card, Bheem UPI or Aadhaar enabled payment systems. However, the Payment Council of India has raised concerns over non-receipt of such reimbursements. The Payment Council of India has said that there have been no reimbursement by banks with respect to MDR despite a government notification which was issued in January 2018. Hence, in this aspect, the Payment Council of India has raised concerns. Now, this is the focus of the article. Now, let us go back to the question which was asked in the year 2018. So, the question asked was, which of the following best describes the term merchant discount rate? First was incentive given by a bank to a merchant for accepting payments through debit cards. No, it's not an incentive. B. The amount paid by banks to their customers. No, this is incorrect as well. C. The charge to a merchant by a bank for accepting payments from his customers through the bank's debit cards. Yes, this is the correct answer. However, let's look at option D. It says incentive given by government to merchants for promoting digital payments. No, this is not an incentive but rather a charge. As you can see, that merchant discount rate is a charge to a merchant by a bank for accepting payment from their customers in either credit or debit card transactions. Thus, in this, C was the correct answer. Hence, this news on MDR reimbursement pending from banks becomes important from an exam perspective. With this, let's move on to the next news. Now, the next news appears on page number 9 in data point. It says about a high TB burden. It says 1 in every 4 TB cases registered in 2017 was in India. Now, this is a very significant alarm with respect to the cause of TB in India. However, among the 30 countries with the highest TB burden, India's incident and mortality rates were below the average. Now, in this particular diagram, it talks about in this axis mortality rate, and in this axis, it talks about incidence per 1 lakh people, where it says size of circle indicates percentage of total TB cases worldwide. So we see the size in terms of percentage is maximum in the case of India as compared to either Bangladesh or even Pakistan. And we can also observe that even in China, there are large number of cases of TB. So in this aspect, the report says that India and China are home to the highest cases of TB. And the source for this particular data point is WHO, that is World Health Organization, Global Tuberculosis Report 2018. This particular paper forms a part of GS Paper 3, specifically under Science and Technology, and also awareness in the field of nanotechnology and biotechnology, specifically with respect to multi-drug resistant TB. So in this aspect, let's understand the case of TB in India and also the different kind of multi-drug resistance. It says that in India, each year approx 220,000 deaths are reported due to tuberculosis. And India is the highest TB burden country. So out of 9.6 million cases globally, India accounts for roughly 2.2 million cases of TB. Further, it says that TB is India's biggest health issue. But what makes the issue worse is the recently discovered phenomena of TDR-TB, that is totally drug resistant tuberculosis. So this TDR is a new phenomena observed in India. It then says that the issue of drug resistant TB began with this MDR TB, that is multi drug resistant TB. However, it moved to XDR TB. So from MDR, we moved to a situation of XDR. Gradually, the most dangerous form has situated itself in India as TDR. So from MDR, it resulted into XDR, and from XDR, it has resulted into TDR. So we can see a complete cycle from NDR towards TDR. So in this aspect, let's understand about this MDR, XDR as well as TDR. It says that MDR, that is multi-drug resistant tuberculosis, is a form of TB infection caused by bacteria that are resistant to treatment with at least two of the most powerful first-line anti-TB medication. So these MDR are resistant to at least two of the most powerful first-line anti-TB medication. And the two most powerful first-line anti-TB medications are isoniazid and rifampin. Further, it talks about XDR-TB, that is extensively drug-resistant tuberculosis. This XDR-TB is a form of tuberculosis caused by bacteria that are resistant to some of the most effective anti-TB drugs. And these XDR-TB strains have arisen after the mismanagement of individuals with multi-drug resistant TB. So the strain of SDR has resulted after the mismanagement with multi-drug resistant TB. Now then it talks about TDR-TB, that is totally drug resistant TB, which has recently discovered in India. And this is also highly dangerous. It says it is a generic term for tuberculosis strains that are resistant to a wider range of drugs that strains classified as extensively drug resistant tuberculosis. So this TDR, that is totally drug resistant tuberculosis, is resistant to a wider range of drugs. And another important information with respect to TDR-TB is that it has been identified in three countries, that is India, Iran and Italy. And this emergence of TDR-TB has been documented in four major publications. However, this TDR-TB has yet not been recognized by the World Health Organization. But still, strains of this TDR-TB has been identified in India, Iran as well as Italy. So we see this data point on various kinds of TB including MDR-TB, XDR-TB and TDR-TB becomes extremely crucial for us to understand with respect to the health significance of individuals who are suffering from these kinds of TB in India. Now, a question was asked in the year 2014 in GS paper 3. The question read, can overuse and free availability of antibiotics without doctor's prescription be contributors to the emergence of drug-resistant disease in India? What are the available mechanisms for monitoring and control? Critically discuss the various issues involved. So we see question based on free availability of antibiotics, which is causing this huge concerns with respect to drug-resistant diseases in India, has been asked by UPSC. Hence, in this aspect, this data point on high TB burden becomes extremely important. As WHO in its Global Tuberculosis Report 2018 has identified that out of 9.6 cases globally of TB, India has roughly around 2.2 million cases of TB. And this in itself is a cause of concern. Hence, this data point becomes extremely important to understand as the size of the circles in this map indicates percentage of total TB cases worldwide, where India and China are home to the highest number of TB cases. With this, we come to an end to discussion of today's newspaper. Let's move on to the question for the day.